There are two categories of reasons to evict a tenant. One category is the failure to pay rent, and the other category is every other reason to evict a tenant. Evicting a tenant for failure to pay rent is fairly straightforward. We generally know how the judge will rule in a failure to pay rent case. Evicting a tenant for any other reason, such as destroying the premises, loud parties, unauthorized pets, and so forth, is another matter. We may be able to prove that the tenant has defaulted under the terms of the lease, but especially in the liberal counties Fulton and DeKalb in Georgia, the judges in landlord-tenant court generally act as advocates for tenants, and as a landlord, you really have to prove your case. Having loud parties may indeed be a lease violation, but a particular judge may not give you a writ of possession over it. Here is how you would evict a tenant for a default other than failure to pay rent. Let's say your tenant has an unauthorized pit bull and refuses to get rid of the dog. If your lease prohibits pets unless there is a duly executed pet exhibit attached to the lease, then the tenant is in default. Here are the steps you need to take, and these steps apply for every reason to terminate a lease other than failure to pay rent. To evict a tenant for a reason other than failure to pay rent, you must give the tenant notice of default, terminate the lease if the default is not cured, and then you can evict the tenant for holding over after lease termination. Here are the specific steps to take. First, notify the tenant in writing that the tenant has defaulted under the terms of the lease. Specify the violation or the default very carefully and clearly. Tell the tenant what you want the tenant to do, in this case, get rid of the dog. Give the tenant a specific amount of time, for example, 1 week, and tell the tenant that if the dog is not gone in that amount of time, you will terminate the lease. Letters for this purpose are available at the DIY Landlording Resource Library that is a part of this series. After the specified time has passed, then you must demand possession of the property in writing. That is the subject of this video, the form letter, Demand for Possession After Lease Termination. After you have sent this demand letter, you may then go to the courthouse and file for a dispossessory warrant. My name is Andy Ritan, and I am the owner and broker of Ritan Property Group, a residential property management company in Atlanta, Georgia. My demand for possession of premises after lease termination form letter is available for free as a part of my DIY Landlording Resource Library, which you may download from my website, www.houseatlanta.com. I am not an attorney and do not provide legal advice. The materials available at this website are for informational purposes only. You should contact your attorney to provide advice with respect to any particular issue or problem. Good luck out there. If you should decide to seek out a professional property management company, I hope you'll remember me.